Banking Law Notes by MG Law. Today we will cover the topic holder and holder in due course. Two topics, okay? So we should go to page number 19. Okay, now holder and holder in due course. First we will see who is a holder. According to Negotiable Instruments Act, Section 8, any person, okay, who has a right to possession and receive or recover. Two rights. First is possession. Who has the right to take possession of any instrument? Instruments are like check, bill of exchange, or promissory note. Okay, whoever has a right of the possession, okay, he will be the holder. Or whoever has the right to receive or recover the amount, like the amount stated on this instrument, like check on which the amount stated is 1000 rupees, then he has the right to receive this amount from the bank or any other acceptor. Or he has the right to recover the amount, like if he goes to the bank and the bank denies the payment, then he has the right to recover from the drawer of the check. Whoever has drawn the check, he has the right to recover from all those parties. Okay, so from the definition we will get the essential points also, like what are the essentials of a holder. These are right to possession and right to receive or recover, which were all we already discussed in the definition. So right to possession, obtain possession by, if anybody obtain possession by unlawful means, like by fraud, then he is not a holder. Okay, like thief, he has steal from anywhere, or like he has found it somewhere, then he's not a holder. He doesn't have the right to possession. Okay, these two. For example, a steals check from B's possession, okay, then A will not be a holder. Okay, A will not be a holder. B will continue to be holder. What are the rights of the holder? The he These two we have already seen: right of possession, right to receive or recover. Three extra are: he has the right to endorse. The holder can endorse to anybody else, like he can endorse to A, B, C, etc. Okay, he can cross the open check, like he can cross it like that. Okay, he can convert blank into full, like he has received the check in which the amount is not stated, it's a blank check, then he can write the amount which whatever he wants. Okay, these were the rights of holder. uh, let's have a revision of like summary, like holder according to Negotiable Instruments Act Section 8, any person two rights: right to possession, right to receive or recover. Okay, in the essentials also. And what were the rights of the holder? Possession, recover and receive, and three extra: endorse, cross, or convert blank into full. Now we will see holder in due course. He has more rights, he has more essentials. How? Let's see. Mm. According to Negotiable Instruments Acts, Section 9, any person who has received that instrument for consideration, like he has paid some value or some money for the instrument, like for the check he has, so he has given his land or property, like, okay, then he has become possessor if payable to bearer, and or become a payee or endorsee if payable to order. So what are bearer or order instruments? Like it's like when you see a check, you can see it's written pay A, and now see, or bearer. Okay, it's written on the check, you can check, uh, see online also. So what does it mean? Or bearer means uh, either the bank should pay to A, or whoever is holding the check. Okay, whoever has the possession of the check, or whoever bears that check, the bank will pay to that person. Another is to order, means like it's written pay a or on order of. Okay, it's right. Either the bank will pay to a, or it will pay to whoever a orders. Okay, whoever's name is written on the check, like pay will endorse the check. On the back of check, the a will write pay to c, and write in signs it, then c's name is written. Okay, in order check, the payee or endorsees, here c is the endorsee. Okay, a was a payee. So in order check, payee or endorsee. In bearer check, whoever has the possession of the check. Okay, I think you have understood. And the person should become the holder in due course before amount become payable. It means before maturity, like on the check the date is written 10th February. Okay, the person should become the holder or holder in due course before 10th February, because on 10th February the check becomes payable, it can be encashed, or the amount can be transferred to the bearer. Okay, or the or on order. Okay. uh, and next condition is he is not having any cause to believe or suspicion, like without having sufficient cause to believe that there was any defect in title of person from whom he received the title. It means he has received it honestly and in good faith. He doesn't know, like a gives a check to b. Okay, uh, b doesn't know that a has steal it from somewhere. A is a thief who has stolen the check from somewhere. Okay, he b has taken it in good faith, by giving consideration, by giving his land, and in exchange a has given the check. But b doesn't know that he is a thief, it was not his check. Okay, these conditions should be fulfilled to become holder in due course. So in essentials, also these points are for consideration. Okay, uh, this point of consideration, it's presumed, it's already presumed that the check was taken as a in exchange of consideration. uh, why? Because to secure free circulation of negotiable instrument. Like if we start checking the history of every check, like the payee or the endorsee has gotten the check after consideration, we have to check the history, then the free circulation will become very complex. Okay, so it's presumed until proven otherwise. Okay, next condition was, in condition of bearer he should be the possessor, in condition of order he should be the payee or endorsee. Okay, he should become the holder before maturity, before the uh, check becomes mature. Okay, and he is acting honestly, he doesn't have any doubt or suspicion that there was something wrong, that he was a thief. He was not having any notice of it, he was acting in good faith. Okay, these four condition for country consideration: bearer order, maturity, and in good faith. Okay, you have to learn these four. Now, what are the rights of a holder in due course? These are the rights. He is having a better title, free from all defects. Like if in the previous example we have seen, a was a thief who gave the check to b. Now a is having a defective title, but b has got the check from by paying some value, by giving some consideration, in exchange of consideration. Okay, so b will not have any problem. B is having a better title, his title is free from all defects. Okay, second point is prior parties liable until instrument duly satisfied, means till payment is made, can recover from any or all. Okay, if a gives a check, it's another example, a gives check to b, b to c. Okay, now both a and b are liable to c until c gets the amount. C can, if he doesn't gets the amount, he can take action against both b and a, or either b or a. Okay, it's up to c. And next is inchoate or incomplete instrument, rights of holder in due course not affected. uh, uh, let's see what does it mean. It means like there is a check. A has given this check to B and told B that I am leaving this check blank. You enter the amount 500, and okay. But what B does is B gives this check to C, and instead of 500 he writes 1000. Okay. Now when C goes to take the payment, and A says that I said my intention was only 500, C doesn't care about it. C is entitled to get 1000. He can take action against both A or B, or both, or either A or B for 1000 rupees. A cannot deny A is liable, B is liable. Okay. Originally incomplete, subsequent transferor completed sum greater than maker's intention. Okay. And then holder in due course is not affected by it. He doesn't care. Fictitious bill. Okay. Let's take example of this point. Fictitious bill. Like this is a bill of exchange. There is a party A whose name is A, and there is an acceptor B, and there is another party, or you can say a payee, like C. A tells to B that pay C 1000 rupees on 10th February. Okay, on 10th February. And- But instead of writing his original name, he write a fictitious name like Superman, and signs his name as Superman. Okay, and then like this. And B, when the check was written by A, drawn by A, or bill of exchange was drawn by made by A, B accepted it. Okay, B accepted and signs it. Okay. Now when C goes to B for the taking the amount, B says, "Oh, there is no person as Superman. It's a fictitious name. It's a fictitious person. Okay, I will not pay." B cannot do like that. Okay, C is protected. C can take action against these persons B and A. Okay, he, because why? The when B knows that it's a and it's a fictitious person, then why did he accept it? Why did he sign the bill of exchange? Okay, I think you got the point. Bill drawn on behalf of fictitious person and payable to his order, then acceptor not relieved from liability to holder in due course, provided signature as drawer and endorser in same handwriting. Okay, like the signature as Superman, and when he endorses to C, they should be in the same handwriting. Next point is unlawful consideration and means. Now we will come to see this example also. uh, for example, there is some person B who has lost in gambling 1000 rupees. Now against whom? A. So A draws a bill of exchange uh, on B by saying that uh, B, you will pay 1000 rupees on 10th February. Okay. Now B accepts this bill. He is the acceptor. Okay. Then what happens? A endorses this bill of exchange to C. Okay. For consideration, C has given some property or some good to A, and for the consideration, he has given this bill of exchange of value 1000 rupees to him, and C has taken it in good faith. He doesn't know that it was taken in gambling. Now when he goes to B for the payment, because B is an acceptor, B says, "Oh, this bill of exchange was drawn in due to gambling, and gambling is illegal. Therefore, it's illegal." Eh, in that case, B is protected. Okay, he doesn't care. B will be liable. C is protected. Okay, he will get the payment from the B. uh, A draws bill of exchange on B lost in gambling. B accepts the bill. A endorses the bill to C for consideration. C takes in good faith. B is liable. Okay, I think you have got the point. As we have already seen, there should be some consideration. Without consideration, no obligation. There is no obligation to pay. But if any party transfer to holder in due course for consideration, then there is liability. We have already it's in the main points. Next is estoppel against denying. What does estoppel means? Estoppel means like if you say A is my son, okay, then later after some time you cannot deny this fact if you have already accepted the fact before. Okay, this is called estoppel. You cannot deny it later. So estoppel against denying original validity, like A makes a promissory note to B, B endorse it to C. Okay, A makes promissory note to B, like I promise to pay B, and B endorses it to C. On due date dishonor, he cannot say no amount due. Like when C goes to A by taking that promissory note and say that you promise to pay B this much amount, okay, as per the promissory note. B cannot say, oh, I have already paid B, so there is no amount due. C doesn't care about it. C is protected. A is liable to pay. Okay. Next is estoppel against denying capacity of payee to endorse. Like uh, in promissory note, maker cannot deny the payee's capacity to endorse, and in bill of exchange having order, the acceptor will not deny the capacity of pay to endorse. For example, A endorses A draws a check which says pay B. Okay, here C we have written check. Let's see, it's promissory note. Okay, in promissory note, A writes, I promise to pay B 1000 rupees. Okay, now let's see, B endorses the check to C. Okay, when C goes to A, that you wrote a promissory note like that, and A says, oh, C doesn't have any capacity to endorse this check to you. He cannot do like that. C has all the capacity to endorse it. Okay, next is estoppel against denying sign or capacity of prior party. Okay, no endorser can deny on suit by subsequent endorsee. Let's see from example. What does it mean? Like he writes a check to B, B endorse it to C, C endorse it to D, D endorse it to E. Okay. Now when E goes for the payment, okay, uh, he goes to D. Okay, he says, D, you have given me that check. Now the date has come, so pay me. Okay, so now D cannot say, oh, on this check the sign of B are wrong. Okay, because B is a prior party, sign of B is not like that. It's a fake sign. It's like that. Then in this case, E is protected because he will say that when you knew that sign of B were not real or they are fake. Okay, then why you gave it to me? Okay, that's a common sense. Or if D says that B was not having the capacity to make this payment, okay, then also he will say that if you knew that B was not having the capacity to make this payment, then why you gave it to me? Okay, so no endorser, because D endorsed it to E. No endorser can deny on suit by subsequent endorsee. When E make takes a action against D, he cannot deny it. Okay, so what are the protections available in case of dishonor? That there will prosecution on dishonor after complaint, okay, under section 138. Now let's see the summary of holder in due course. We have already discussed the summary of holder. Okay, holder in due course. First was meaning. In meaning, we saw consideration. There should be some consideration. Next was possessor and payee endorser in case of bearer or order instrument. Next was maturity. Okay, he should be holder in due course before maturity. Next was in good faith. Okay, these are also essentials. Also in essentials also the same condition. Next were rights, like he was having better title. He doesn't care if the previous endorser was having defective title or he was a thief or any finder or okay. All the prior parties will be liable. If incomplete check was completed by anybody and it was taken by the holder in due course, he doesn't care. Okay, if the instrument is written on a fictitious name, okay, and then also he doesn't care. He's protected. If it was written for any unlawful consideration on means also, then also the holder in due course is protected. And if it is without consideration, then there is no obligation to pay. But if it's for consideration, it's in obligation to pay, as we have already seen in the definition. Next was estoppel. There were three conditions which the previous endorsers cannot deny, or okay, or payer or maker cannot deny. It was like we have seen examples like in original validity, it cannot be denied. Okay, then next was the capacity of payee to endorse was it cannot be denied. And the signer capacities of prior parties, these cannot be denied. Okay, next was the protections available, that the holder in due course can make complaint against the previous parties for the dishonor. Okay, and will be prosecution under section 138. Uh, I think you have understood the topic. You can revise this from the PDF. If you revise 1-2 times, you will get all the points. You can memorize it from here. If you want the PDF, you can get it from the description box or the comment box if you are interested. Okay, next topic will be endorsement, which we will see in the next video.